we think about the law, our minds usually jump to crime, right? Police, courts, punishment. Or maybe we think about broken contracts and business deals gone wrong. But there's this whole other universe in the legal world, a place that deals with civil wrongs, where everyday actions can have massive legal consequences. And that universe is governed by the Law of Torts. So think about this for a second. Let's say you get hurt because of a faulty product you bought. The person who sold it to you didn't commit a crime, and you never signed a contract with the company that actually made the thing. So what happens now? Where do you turn for justice? That very question, that gap in the law, is precisely why the Law of Torts exists. All right, to really get a handle on this fascinating area of law, we have to start with the word itself, tort. It sounds a little strange, doesn't it? But its origin, well, its origin tells you pretty much the entire story. The word gives us this incredibly powerful clue. It comes directly from the Latin word tortum, which means twisted or crooked. And that's just a perfect way to think about it, isn't it? You can see the Law of Torts as a way to straighten out a situation that's been twisted out of shape, to correct a civil wrong that's knocked someone's life off its path. It's basically any wrongful act, whether it was on purpose or just an accident, that ends up hurting someone else. Now, the legendary legal scholar Sir John Salmond gave us this really classic definition. And the key phrase to lock onto here is unliquidated damages. I know, it sounds like some fancy legal jargon, but what it really means is that there's no preset price tag on the harm that was done. It's not like a contract where the penalty might be written down in black and white. Here, a court has to step in and figure out what a fair and just amount of compensation would be after the wrong has already happened. And you know, this gets to the absolute heart of what tort law is all about. Its mission is not punishment. We have criminal law to handle that. The purpose here is restoration. The entire goal is to try and put the injured person back in the position they were in before the wrong ever happened, at least as much as money can do that. It's about making them whole again. So to really, truly grasp what a tort is, it really helps to see where it fits and where it doesn't fit in the legal world. So let's draw some really clear lines in the sand by comparing it to the two other big areas of law you probably know, crime and contract. First up, let's put tort and crime in the ring together. A crime is considered a wrong against society as a whole, against the state. And that's exactly why the government, the state, is the one that prosecutes the case. The goal is to punish the offender. But a tort, that's a private wrong. It's between individuals. So here, it's the injured person who sues, and what they're looking for isn't punishment, it's compensation to cover their losses. Okay, now let's compare tort to a breach of contract. A contract creates very specific duties, but only between the people who actually agreed to it. In tort law, though, the duty is much, much broader. You have a general duty not to harm other people, even if they're complete strangers. And like we just said, contract damages are often liquidated. They're pre-agreed upon. But tort damages are unliquidated, meaning they're figured out by a court based on how bad the actual harm was. So torts can generally be sorted into three big categories. Let's kick things off with the most direct kind, intentional torts. This is when the person causing the harm actually meant to do the act that caused it. And here are some of the classics you've probably heard of. Battery is the actual intentional and unwanted physical contact. But what's really interesting is assault. For an assault to happen, nobody actually has to touch you. It's the act that makes someone reasonably afraid that they're about to be harmed. So you can totally have an assault without a battery. And then, of course, there's defamation. That's when someone intentionally hurts your reputation by spreading lies, either by speaking them, which we call slander, or by writing them down, which is libel. But let's be honest, most of the harm that happens in the world isn't deliberate. It's just careless. And this brings us to the single biggest and most influential type of tort there is, negligence. And its modern foundation, well, it all rests on one of the most incredible stories in the history of law. Picture this. We're in a simple cafe. The place is Paisley, Scotland. The year is 1928, and a completely ordinary purchase is about to change the world of law forever. Now, the details here are absolutely critical. Mrs. Donahue's friend is the one who bought her the ginger beer. That means she had no contract with the cafe owner, and she certainly didn't have a contract with the manufacturer, a man named Stevenson. But she was the one who was harmed by his product. This created a massive legal puzzle that went all the way to the UK's highest court, asking a really basic question. Did the manufacturer owe any kind of duty to her at all? And the answer that came from Lord Atkin was nothing short of revolutionary. He established what we now call the neighbor principle. He said your neighbor isn't just the person who lives next door. In the eyes of the law, your neighbor is anyone you can reasonably predict will be affected by what you do. This ruling was a bombshell. It completely changed the game. For the first time, the law was saying loud and clear that a manufacturer has a responsibility, a duty of care, to the final person who uses their product, and that this duty exists completely outside of any contract. This one case created the foundation for all of modern negligence and product liability law. So, we've covered intentional harm, we've covered carious harm, but here's a wild idea. What if you could be held liable even if you weren't at fault at all? Even if you were as careful as you could possibly be? Well, that brings us to our third and final category, no-fault liability. This concept is known as strict liability, and it comes from another huge English case, Rylands v. Fletcher. The core idea is this. If you decide to do something abnormally dangerous on your land, like say building a giant reservoir, you are strictly responsible for any harm it causes if that dangerous thing escapes. It doesn't matter how careful you were trying to be. But then, in India, after some truly tragic industrial accidents like the oleum gas leak, the Supreme Court took a look at this idea of strict liability and decided it just wasn't enough. So in the landmark MC Mehta case, the court created an even more powerful, more stringent rule. Absolute liability. And the differences between them are just night and day. Under the original English rule of strict liability, the dangerous thing had to physically escape your property for you to be liable, and there were several defenses or excuses you could use. But under India's rule of absolute liability, escape isn't even required. And here's the kicker. There are zero exceptions. If you run a hazardous business and it causes harm, your responsibility is absolute. Full stop. So after this whole journey, through intention, through carelessness, all the way to no-fault wrongs, what's the big takeaway here? What's the grand theme? It all comes right back to the central purpose of tort law. When you step back and look at it, the law of torts is like this huge protective net. It safeguards your physical self. It protects your property. It even defends your reputation from the wrongful acts of other people, whether those acts were done on purpose or were just flat out negligent. If there is one single idea that you hold on to from all of this, let it be this one. The entire massive structure of tort law is built not on a foundation of vengeance, but on a foundation of repair. It's about fixing what was broken. It's about restoring what was lost. You see, it all comes full circle, from that ancient Latin root, tortum, meaning twisted, all the way to its modern use in courtrooms today. The law of torts serves one profound purpose: to make sure that when a wrongful, twisted act causes harm, the arc of justice always bends back to make things right.